Thank you. Just get him in here so we can go ahead and put it on the screen.
He identified as having an intellectual incapacity.
Hold on, we'll put it up on the screen so like that they can see it.
And it's really hard to see that because we saw what was going to be presented to the grand jury, and that was not what was presented to the grand jury.
How's Wendy doing today?
Bad, really bad.
Armando's very, very angry.
I know we're waiting real quick, but since you've already started talking, can you just go ahead and identify yourself just so we
Oh, I'm so sorry. I'm April Aguirre. I'm Wendy's sister. And we can start over.
Can you spell your first last name?
April Aguirre, APRILAGUIRRE.
And my name is Rick Ramos. I'm an attorney here in Houston, and I represent the Alvarez family. And Carlos Mejia is here with me to my right. We have one of the investigators on the case, which has helped out at least gather as much information as we could, and that is Mr. Ruben Davila. And we're here on behalf of the family just to give you a status on basically on our response to what transpired yesterday after the grand jury returned and then ended up with a no bill for Mr. Tony Earls on the criminal charges that were pending at that time. And when we basically, the way that we looked at it, we're very disappointed. We don't think that the DA's office did anything wrong. They worked hard. They put an endless amount of time and hours into the case. But I think that the case could have probably been presented a little different. I think Mr. Earls, as an example, and Albert, if you can just pull up the document that Mr. Earls filed early on in the case shortly after he was arrested and charged with aggravated assault. The one after that, please. One after that, yes. Mr. Earls had filed a document. It's called an early identification of suspected mental illness or intellectual disability. And basically what he claimed at that time, and they found that there was credible evidence that established that reasonable cause to believe that the above named defendant, that was him, had a mental illness or an intellectual disability. And then the finding was that it was in the year preceding his arrest. So essentially, at that point in time, you have an individual by his own account with a mental illness or an intellectual disability that actually is in the possession of a handgun. So now we can start there. The next issue is when the case went to the grand jury, under the pretense that Mr. Earls was permitted then to raise a affirmative defense that he was essentially in a self-defense mode, meaning imminent threat of fear for his life, of his spouse, or property. And the standard is a reasonable belief on the basis of an ordinary prudent person, except that Mr. Earls did not have the capability to exercise an ordinary reasonable belief of a prudent person because he doesn't have the intellectual capacity by his own account to do so. I think if the grand jury would have heard that, I think they would have been able then to formulate that his behavior was in fact reckless. And then if you go to the statute where it allows you then to exercise self-defense, go on, Junior, on the next one. This is a reckless injury of innocent third party. So even though you are justified under this chapter, threatening or using force, deadly force against another, if in doing so recklessly injures or kills an innocent third person, the justification of self-defense afforded in this chapter is unavailable to you in a prosecution for the reckless injury of killing of the innocent third person. So what was Mr. Earls charged with? So go back to the indictment. That's what he was charged with. He was charged with hereafter style defendant, herefore, on or about February 14, then and there unlawfully and recklessly cause serious bodily injury to Arlene, here include the complaining, by shooting into an occupied motor vehicle and killing her. So if you use the defense of I'm going to go ahead and defend myself, does not give you the right then, in a reckless manner, to go ahead and then kill a third party. And he did this under the pretense that somehow he thought, even though he does not have the mental capacity, that the one individual that robbed him after the robbery, somehow got in a car with multiple robbers to leave the scene. He was robbed by one person, not multiples. So consequently, his belief system is that somehow now gave him the right to go ahead and shoot into a vehicle with other individuals under the pretense that they're in fact robbers. We don't believe that any of this is on the basis of reasonable belief because he doesn't have the ability to formulate it. I think that if the DA's office would have taken this approach, I think that would have negated Mr. Earls' ability to come forward and even put up a defense or a claim of justification, number one, or self-defense, that he was defending himself or defending his spouse. The shooting itself, if you track the sequence, began when Mr. Earl stepped out of the vehicle. That's when the shooting started. The robber did not shoot during the context of the robbery. The robber was leaving the scene. Mr. Earls got out of his vehicle, and that's when the confrontation started. So you have to be accountable for your behavior at some point in time and say, would an ordinary person, after you've been robbed at gunpoint and your robber's leaving, are you going then to get out of your vehicle with a pistol with their back to you, and then another sequence of events will begin, which constitutes a different crime, which is your reckless endangerment that ended up causing Arlene Alvarez her life. That's what this case is about. I think when you do it and you want to go ahead and provide a sequence of events, you're going to sit there and you're going to victimize Mr. Earls. And if you saw Mr. Earls unload that pistol on that vehicle repeatedly over and over and over and over again, it's hard to feel any sympathy. And he left the scene. It's not like he stayed. The man took off. He went to his house, placed a 911 call after the fact that he had been robbed. Didn't call 911 at the scene, didn't bother. It was a calculated measuring stick for him then to contact the authorities because he knew something bad had happened. He knew he did something bad. And if you put the case in proper context, that's what it's about. Yes, the robbery was bad. Yes, we do feel bad that he was robbed. But at some point in time, he became a perpetrator. And he became a perpetrator because he was mad that he got robbed. He was upset, he was angry, and he had a gun, and he was going to take that gun, and he was going to start shooting. And somebody got killed in the process. It's reckless behavior. And I think if the DA's office would have presented it in that format, I think you would have probably had maybe a different result with the grand jury. You could still go back and present again in front of the grand jury, maybe with a different grand jury. This is not a final jury verdict. Jeopardy does not attach. You have not been tried, which means at no point in time did he have the ability to lose his freedom. A grand jury, all they do is examine the actual complaint and the charge against you, and they view it and grade it to see if there's probable cause for that case to continue, and you are indicted with the offense of aggravated assault with a deadly weapon. So I think if the case would have been presented from this fashion, I think you would have negated Mr. Earls' ability to even come forward and in good conscience after he followed his paperwork in court, which, by the way, it's under seal. So his entire mental history is under seal in court under that court order, which has reasonable belief that he is in fact a mentally ill individual and does not have the mental capacity to be able to formulate the thought process that led him to the shooting. So what he says is, I did the shooting. I know I should not have done the shooting. I didn't have the mental ability to really know that it was bad. So please take leniency on me. And then at the same time, he tells you, hey, I acted like any one of us. You can't have it both ways. And I think if you do the case from this perspective, I think the outcome would have been different. The family is hurt. They're in pain. They trust the system. They believe in it. We believe in the prosecutor's office. We believe in law enforcement. But it's kind of hard for them to continue to be law-abiding citizens and really depend on justice when at this point in time they feel like the system has let them down. And Chase Bank, for the most part, I mean, this is a gallery of crime. It's robbery after robbery after robbery. You can't even get a camera that can even give you a description of any one of the individuals that are going on his premises and robbing people after people after people, even in broad daylight. So that there's ample evidence in the last year that this has just gone on and on and on, and it has escalated to the point now where, you know, we have shooting after shooting in the same premises. So this is a sad day for Houston. It's a sad day for this family, just because of the number of children that have been killed this year from gun violence. And I asked you, would the outcome of this case been different if a child would have been hit by a straight bullet from Mr. Earls, sitting in an apartment or a home, minding their own business, and you got shot in the head because he thought he was shooting at a robber? I mean, to me, there's no difference, because it was made in a public area when you choose to discharge a firearm. And again, you're dealing with guns and people that don't have the mental capacity to be carrying a weapon. And, you know, enough is enough.
This morning, we presented the district attorney with the question, did the grand jury get the full picture? Did they know that this file existed? Did they know that he identified as being mentally ill? Because that changes everything for a grand jury. The next question is, if this person can so easily identify as mentally ill and provide documentation, why did he have a gun? We talk about so many laws about mental health, but who's truly enforcing them? And the victim here was Arlene. This man didn't present the weapon when he was being actively robbed. He didn't want to jeopardize his wife's life. He waited until the robber was running away to open fire. While shooting at the robber, if one of those bullets would have hit Arlene, we wouldn't have a case. Our frustration with the system is that this man made a decision to shoot directly into our vehicle. As we were driving by, it could have been any one of you. Grasp that. Unaware of what's going on, driving down the road with just a few yards away, a red light. They had no idea, and Arlene did not deserve to die on a Monday night on her way to dinner. She didn't deserve this. And for her to not get justice, it's just another re-victimization of the family. And we're not going to stand here and allow this to continue. We had to go home yesterday and decide, do we accept this or do we continue to fight? And Arlene and God just keeps giving us nuggets of information, and we cannot believe that this is the first time that we hear that this person identified as being mentally ill. The whole argument was, did he have a reasonable enough, was it a reasonable act? Is it the way you would have done it, I would have done it, a normal person? Well, now we know that this person doesn't identify even himself as a normal individual. This person presented documentation to the court saying, hi, I'm not well.
That's exactly right. That's why he doesn't get the benefit. He doesn't get the benefit of the defense.
Being able to use that.
Because he doesn't have it. By his own account, he can't formulate an ordinary, prudent
reasonable
belief.
thought. He can't. I'm going to send a message to Houston. We have to hold these people accountable. We see so many people pulling the trigger. Most of them are underage, what I see on the news, and people of mentally ill. But you know what? They can pull a trigger just as fast as any normal individual. Arlene deserves justice.
Let me show the photograph of. Do you have the photograph of Arlene after the shooting, Albert? Arlene, right after that shooting, her dad had to hold her. And, in about 30 seconds to a minute, a bystander walked by and actually heard Arlene actually whisper and talk to her dad. As you're sitting there and you have brain matter spattered and you're trying to control yourself as a dad, I can't imagine what this man went through. Then your daughter gets transported by ambulance to a hospital. The perpetrator never bothered to stop. He went home and then he called 911. And then as you sit there and you're watching your little girl just like that.
Look at her. Look at what they did to her. Tell me that that's not guilty. Tell me that it was an accident to pull a bullet in her head. It wasn't an accident when you intentionally shoot into a vehicle. That was not an accident. That was not self-defense. Arlene's the one that couldn't defend herself. We couldn't defend her from somebody that acted in that manner. We couldn't stop bullets from coming into our truck. We couldn't stop the bullets from coming into our truck. We couldn't. We couldn't protect her even though she was in arm's reach away from her mother and father.
Mr. Earl needs to understand that the grief for this family is deeper than anything he can ever imagine, because this family had to make a conscientious decision as to whether or not their baby girl, their daughter, was going to be cut off as a human being and be placed and be put basically to go away peacefully. And that's a hard decision for a family to make. And they had to do this in the context of a 36-hour span where your life is completely turned upside down because you have a mentally ill individual with a pistol that reacts in what we feel is a reckless manner based on the evidence, and shot multiple times at a family vehicle when he himself was never taking any gunfire from that vehicle. That vehicle was driving away, and he sat there and he went ahead and targeted, and he made sure that every single round that he had left in that pistol went right into that vehicle. And that is reckless, and that's why we're here.
Yeah, I agree with Rick entirely on this. Not only was the
Move the mics down to this picture.
Let me know when you're ready. Yeah, I agree with Rick entirely on this. Not only was Mr. Earl not receiving fire from the vehicle, but the assailant, the robber, was running away at the time. Not only was the robber running away at the time, but the robber had relinquished the property that was allegedly being taken by Mr. Earl. There was really no reason for him to pull out his pistol and fire an entire clip into a van that was to a truck that was passing by. It's absolutely ridiculous, and
The law is, and the law is clear. This is the flat out the law, castle doctrine under the state of Texas. You know what? You're presumed to use reasonable force under a reasonable belief if you are currently in the commission of being carjacked out of your car. Okay? That's the first one. The second one is if you are currently in the commission of an aggravated robbery. That robber walked away. The commission of the robbery was over, meaning he doesn't get the presumption. Then after that, it becomes a fact issue to go in front of a jury. It was not for the grand jury to then step in and say, King's X, this never goes forward, and he never gets in front of a jury. I think this should have never gone this way, because Mr. Earl, by his own belief, was not capable or did not have that defense available to him by his own paperwork that he placed in court. And I think that's the upsetting part. This needed to be decided by a jury of our peers. And if he thought that it was self-defense, then you know what, put it up in front of a jury, but not in front of a grand jury claiming something that, in the reality, the facts don't dictate your reaction as being one of an ordinary prudent person, because you don't have the intellect or the mental capacity to act as an ordinary prudent person. And that's what you told the judge, because you wanted leniency on your behavior. You thought it was bad. You thought it was a bad decision. So you wanted the judge to take into account the fact that you had a mental illness. But all of a sudden you don't. So I think that's the issue for us. We're going to go back and talk to the family. They're hurt. They're in pain, but we got to push forward. This is a calling card, I think, for Houston. Gun violence is rampant. I think that mental illness is one of a major factor affecting our community. Anytime you have the ability to get a gun and there's no checkpoints, and you have people walking around that essentially should not have the ability to carry a gun, because you don't have the mental capacity to formulate and make good judgment calls when you have the ability to take a life. I mean, that's a big responsibility. So that's it's sad, but we're going to keep pushing, and we feel poorly for the family, but you know what, we'll see where this ends, but we're not going away anytime soon.
I wanted to make sure that the grand jury got the full picture. To my understanding, not even our prosecutor knew that this form was filed. So if our prosecutor didn't know, I know our grand jury never got the full picture of what happened here that night. You have somebody who didn't have the mental capacity to act rational. He didn't have the mental capacity to act rational. And all of that cost the life of Arlene. Wendy and Armando couldn't be here today, because not every day is a good day. Not every day is a strong day. We have stood for months in front of these cameras trying to get justice, and we're not going to stop, because we've already lost everything. We have nothing to lose. We're not going to let this case get swept under the rug. It's been too many children, and Arlene is just one of them. And on their behalf, we're going to continue to fight for justice and make sure every piece of evidence is being presented accurately as it is. We knew coming into this that it was going to be a hard case, but nevertheless, a life was lost, and we need justice. And we're not going to stop showing up. Everybody's going to know Arlene Alvarez's name. Everybody's going to know her name. This case will change the city of Houston and its behavior. It ends here.
And thank y'all for coming today. Again, it's a sad day for the family. We just wanted to make sure that the community knew that we're very thankful for all the support that the family has received throughout this horrible ordeal. We have people that have come out of nowhere that you would never expect to actually show their support, their sympathy, their caring words that have really pushed this family over the top. Houston cares genuinely about people, and we have seen a pouring of emotion and support from the city towards the Alvarez family, and that's one thing that has really come out of this that we're very thankful for, that it has brought the city together, and we're very thankful to everyone that has come out and encouraged and supported the family through this difficult time. So thank you very much, and we appreciate it.
Counsel, you take a question?
Yes, sir.
Before to the question, can you speak in Spanish?
Absolutely, absolutely.
Just a quick question. Are you asking that the grand jury, new grand jury, hear the case again, that the prosecutor's office request a new grand jury?
Yes, I do. I because I believe in the case. So I do believe that they should go ahead and request a different grand jury and be able to represent the case maybe from a different perspective, and more likely than not, you're going to have a different outcome. I think prosecutors are smart. They learn from their mistakes, and I think they'll be able to clean up maybe what they feel, maybe things that shouldn't be done that they could have done differently, and lawyers are hard on themselves. So I do think that the case warrants that on the basis of the evidence and of the facts. And I would like to say that in Spanish that esto es un día pero bien pesado para la familia. La familia está pero bien triste. Esto es un evento, lo que pasó ayer, que la familia verdaderamente no estaba esperando lo que pasó ayer, mentalmente, emocionalmente. Y cuando oyeron lo que había pasado, pues es como viene la tristeza de perder la niña otra vez, como te están dando en el corazón otra vez, y eso lo hace la familia sentir pero bien mal, bien pesada con el sistema, porque son gentes buenas, gentes legales, gentes que le gusta el sistema de Estados Unidos y quieren justicia y creen en la ley y creen en los fiscales y en los jueces, y en estos momentos pues se ven como están perdidos, como si el sistema no lo estás oyendo, no está trabajando el sistema por lo que le pasó a Arlene. Y entonces pues esas son preguntas bien fuertes que a veces nosotros como abogados tenemos que explicarle a la familia, pero lo que siente esa familia de dolor es algo que no se puede poner en palabras en estos momentos, y también tienen que seguir, tienen otros niños, otros familiares que los necesitan a mamá y papá, pero es difícil funcionar diariamente como mamá y papá, cuidando a los otros niños, a los primos, a los abuelos y a otras personas, y entonces pues nunca hay el tiempo que necesita mamá y papá a veces para entrar en un estado mental donde pueden ver la niña y verdaderamente pues pensar lo que pasó y absorber más o menos para seguir adelante. En estos momentos pues están viviendo esta tragedia diariamente. Cada día que el papá se levanta, Armando, es el día febrero 14 otra vez, mano. Es ese día otra vez. Él no puede pasar de ese día mentalmente.
Y encima de ese dolor, ellos tienen el problema que no han podido buscar justicia en el caso. Ellos sienten que son personas que cumplen con todas las leyes, que cumplen con sus deberes a la sociedad, a su comunidad, y cuando llega un momento donde la comunidad, la sociedad y el sistema tiene que responder por ellos, ellos sienten que en ese momento les falló. So, imagínense cómo uno puede recuperar, como una familia que le mataron a la hija, que sienten que en una reunión secreta del gobierno donde nadie pudo atender, ellos no pudieron ver lo que estaba pasando, no pueden entender lo que está pasando adentro, y ellos en esa reunión secreta decidieron no darle justicia a la familia. Ni pudieron ir a un juicio, sentarse y dar testimonio, ver al jurado.
Escuchar el proceso.
Ellos merecen por lo menos eso,
Sí.
que el sistema funcione para ellos también.
El sistema es
Nos falló.
algo que en estos momentos ha fallado. La comunidad no ha fallado. La gente de Houston no han fallado. Pero el sistema en estos momentos pues ha fallado a la familia y la familia cree en el sistema. So, hay que seguir adelante y perseguir la justicia para la niña, porque eso es lo que la niña se merece y la familia se merece eso para que puedan entonces mover adelante con su vida y no tener que estar viviendo febrero 14 diariamente por la pérdida de la niña.
Y voy a hablar por Wendy Armando y les voy a decir que no todos los días son fáciles. Ayer fue un día muy difícil y nos puso en nuestras rodillas porque le tuvimos que pedir a Dios qué hacemos. Dejemos que esto siga pasando, dejemos que recibir nomás la palabra y decir, ok, ya es el fin. No podemos. Tenemos que seguir luchando porque esto no se va a quedar así. Hoy en la mañana nos dimos cuenta que existen documentos que dicen que esta persona tiene un problema mental. Él mismo puso los papeles en la corte al principio cuando lo arrestaron. ¿Cómo es posible que el jurado no vio esta información? Porque nosotros ni sabíamos, porque todos los documentos que hoy vimos no los accesíbamos hasta hoy porque el caso ya está cerrado. Y rápidamente los guardamos y yo inmediatamente le hablé al licenciado y le dije, ¿estoy loca o es lo que yo estoy leyendo? ¿Me estoy entendiendo bien? Porque yo como que no entiendo por qué existe este papel. Nunca me han dicho nada de que el señor había dicho, yo tengo problemas mentales. Él solo lo dijo y no solamente lo dijo, pero presentó evidencia diciendo, mira, aquí están mis documentos, yo no estoy bien. Pero él como quiera tenía arma. Y él pudo matar a una niña de 9 años completamente 100% inocente con esa arma. Y no se puede quedar así. Houston no se puede quedar así.
Si ustedes quieren, esa evidencia fue puesta en un bond hearing, donde él fue para que no le pusieran el número que le habían puesto de la financia. Y entonces pues puso una defensa, ¿no? Que mentalmente pues no podía trabajar, no podía hacer muchas cosas y por eso pues quería una financia del bond bien baja. Entonces puso la evidencia con los papeles en la corte que están sellados, pero hay evidencia que ese señor tiene un problema mental y está en el último año, es la evidencia donde hay el problema mental del hombre, pero no lo podemos ver porque está abajo de un sello, pero él es el que puso su posición mental adentro de la corte, y porque la puso adentro de la corte como una defensa, nosotros tenemos el derecho de verla. Si no lo quieres poner, entonces pues no lo podemos ver, pero si lo pones, tenemos derechos a verlo. Yeah, shoot.
District Attorney Kim yesterday was saying that they want to focus the attention now on the actual robber. Earl's attorney told us that he believes the district attorney's office should have used their resources, should have focused on the robber to begin with. What's the family's response and your response to the fact that Earl's attorney is saying that the DA's office should have focused their attention on the robber and not Earl's from day one?
Well, the issue is simple. See, the robber didn't shoot Arlene.
Right.
So we can start there. So yes, the robber robbed, aggravated robbery, Mr. Earls, but the robber didn't empty the clip into the family vehicle and blow her head off. So what happens is you're focusing your investigation almost as, you know what, it's diversion. It's like we're going to look here instead of your behavior, because you were the shooter, Okay? So you have to take into account the circumstances of the shooting, what happened and transpired during the shooting. The robbery was a part of it, but again, the robber was walking away. He had his back turned. That robbery was over and done with. He took the purse, threw the keys. At that point in time, there is nothing left to say. He is leaving. Mr. Earls then conscientiously gets out of his vehicle. That's an action that he created. That's what he did, not the robber. The robber's walking away. So at what point in time does this become then an issue where Mr. Earls has to be accountable for his behavior, stepping out of that vehicle with a pistol, knowing that he's got a mental illness, and he's going to go ahead and start discharging his firearm in the middle of a parking lot? I think that's reckless, and I think that's the focus. It's his behavior, cause of death, shooting, shot by who? Mr. Earls, not by the robber. The robber's guilty of what he did, aggravated robbery. You know what? He robbed somebody with a pistol. Yes. You know what? You should be charged. You should be investigated for it. But this is not an aggravated robbery. This essentially is an aggravated assault with a deadly weapon that led essentially to the death of a child. That's it.
What's your next steps right now in getting justice for Arlene?
We are going to have a independent counsel. I'm not going to reveal his name yet. We're meeting with him next week on Wednesday. He is a very prominent criminal defense lawyer here in the country, and he is going to review the evidence that's currently present in this case. On the basis of that review, then, he will sit down with the family and provide explanations or guidance, if you will, of, okay, this is the perspective that this case was looked upon, if it was maybe presented different outcome, or maybe not. But the family will get some answers, at least on that issue, from an independent consultant that I think will be able to help maybe answer some of the questions that the family has. So they're not sitting there beating their heads up against the wall without getting, the proper response or excuses why things maybe weren't done. That's the next step.
Is the district attorney's office aware of your concerns and how they presented it?
This morning, when I found that document, the first thing I did was call them. I called them and I said, what is this? What am I looking at and why didn't I know about it? We're very involved with our case, and we're very much after justice because it's all we have left.
And we have to look at it objectively as well, and that's one of the things I think that we've done a fair job in this case is objectively looking at the evidence and not looking at it from our perspective, but looking at it from Mr. Earl's perspective. And again, once you make the conscientious act to go ahead and open that door and come out of your vehicle, a sequence of events took place thereafter. It was not before when the shooting began. It was once he opened that door, he climbed out of that car, and he had that gun, and he felt the need that he was going to confront that robber, or the robber saw him, which I don't believe, because the audio that's out there shows a fast clip shooting sequence that does not equate with I got shot at one time and then I returned fire. It's a sequence of tung 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 tung, and then the robber tung 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 as he's walking, running away at that point in time, and then Mr. Earl empties out the rest of the clip on a car when he's not taking fire. There's nobody in it that's a threat to him, but apparently he thought there was, and that's why it's an irrational belief, because he doesn't have the mental capacity to go ahead and act as an ordinary prudent person. He just does not have that mental capacity. He should have never been afforded that type of defense or that type of justification for his behavior for killing Arlene Alvarez.
Do you think, just real quick, a lot is being said, but do you guys think that the way the DA's office presented this case to the grand jury, did they drop the ball?
Absolutely. I know they worked really, really hard, but the reality of the matter is that the robbery suspect, as soon as we come into the picture, right in front of Chase, this is us, and the robbery suspect passes us. The only people involved at that moment, it's our family and Mr. Earls. He was completely out of the picture.
And again, he wasn't robbed by multiples. He was robbed by one person. So that doesn't give you the right to open fire. I know that, dropping the ball is harsh. I'm not saying that they dropped the ball. It's all about the presentation. And sometimes, when you get caught up in a case and you believe that maybe you should present the facts in a certain way, maybe if somebody, eyeballed it a little bit different, then you would have gotten a different intake, maybe, and done it differently. And that's what we're saying. There should have been more collaboration, I think, in order to come up maybe with a different idea or a different technique to present the case, knowing very well what Mr. Earls was going to say, which is self-defense, justification. I had the right to go ahead and then defend myself, my property, my wife. If you know he's going to say that, then you know what? Legally, then what is your counter to that from a legal perspective with the facts that you have available to you in front of that grand jury? And that's all we're saying.
And I'm gonna be very honest. I am done being polite. I'm gonna tell you what harsh was. Harsh was having to bury that baby. Harsh was having to make the decision to disconnect her. That was harsh. I don't care whose feelings get hurt. We were served an injustice, and we're not gonna accept it.
Do you feel like HPD did what it needed to do to find the actual robber, or they changed their attention to just the shooter?
I'll be really honest with you. We don't have the resources for police officers to be proactive. We're reactive. These officers are overrun. We don't have enough officers to deal with the crime here in Harris County. We don't. Do I believe that they've given an adequate amount of time to search for this man? No. They don't have time and they don't have the resources.
And the other thing that really comes to mind is, you have a new city ordinance now with cameras. There's a reason for that. Is the reason why we wanted the cameras to begin with, and I'm a big proponent of that, is to get a description on a perpetrator. I mean, that helps law enforcement immensely. If we can go ahead and depict the crime on the premises, and you got a clean view with a great camera, you're at least able to get a description. You can get maybe some information on a car. You can do something that then HPD can follow up on.
To help
But you
them.
can't have them just go ahead and fly blind with very, very little information as to what transpired, and then you're looking at a ghost. You're looking at a guy that was wearing a hoodie, may have wearing a mask or not, dressed in dark clothing, running down the street. You can't really get a good angle on what he looks like. I mean, we're asking for a lot. I mean, they did canvass, but you know what? I think on the private side, the private sector now needs to do more. I mean, if you know this is going on your premises, then you know what? You have an obligation to go ahead and at least put up the ability to collect the data or evidence and then submit that to HPD so you can make their life just a little bit easier to
Help
be able to
them.
find
Help them,
a
help
perpetrator.
us.
Right. And that's going to create, some confidence, I think, in the general public as far as knowing that, hey, we're in this together and we're able to find people that are actually committing crimes, because right now we're failing miserably at it.
Pero nos pudieras decir en español breve que uno, que es de Wendy hoy, cómo está emocionalmente y emocionalmente qué ha sido para la familia durante los últimos días y meses.
La familia no duerme. La familia llora diariamente. La familia cree que la niña va a aparecer por la puerta dentro de una hora, porque es bien difícil aceptar que la niña está muerta. Esta era una niña que cuidaba a todo el mundo en la familia. Era una niña que era una gran personalidad. Era una niña que era la mejor amiga de su madre. Iban al trabajo juntos, era alguien que estaba ahí. Esto es una familia que es bien junta, una familia hispana que verdaderamente pues son familia de familia, comen juntos, hacen todo juntos. Y entonces pues cuando ese miembro de la familia no está ahí, una niña de 9 años que en estos momentos se desapareció de este mundo porque alguien la mató, la familia no puede vivir en estos momentos, no puede vivir porque diariamente uno no puede trabajar. Diariamente uno no puede estar en el teléfono, diariamente uno no puede estar en una conversación con un vecino, porque todo esto ha consumido a uno emocionalmente. Por eso es bien difícil y no se va a ir fácil. Esto es algo que esta familia tiene diariamente que vivir con esto que le pasó a la niña. Por eso digo, diariamente es febrero 14 para esta familia. Y entonces pues viene el miedo. Dejan al otro niño salir a la esquina para jugar en un parque. Ahora no pueden salir. Todo el mundo está vigilando a ver lo que va a pasar ahora. Están viviendo totalmente en un estado donde esto es Estados Unidos. Uno no puede vivir en esa clase de miedo, pero así está viviendo esta familia por lo que pasó. Y por lo que pasó es algo que vino una bala que nadie estaba esperando esa bala que le iba a dar ese daño y matar a la niña. Y le pasó a esta familia cuando no estaban haciendo nada, nada más que estaban haciendo lo que hacen las familias. Estaban juntos, iban a comer, iban al banco. Nada más.
Y para contestarle, Wendy está muy mal. Wendy está muy mal. Armando también. Toda la familia estamos tan decepcionados porque es todo lo que nos queda es tener justicia. Y para tener que enterrar la niña, desconectarla, celebrarle el cumpleaños ahí donde la enterramos, es muy feo que también nos digan no hay justicia. Todo lo que hemos sufrido para que digan no hay suficiente evidencia, la mató en video. Hay un video donde la asesinaron. ¿Cómo es posible que no haya suficiente evidencia? Nadie me puede decir a mí que ese hombre no le disparó a la camioneta directamente.
Con el intento de matar.
Con el intento de matar. No hay otro, no puede salir nada más de la situación. Cuando tú disparas adentro de un carro, una camioneta, es para matar. No es para nada más. No es para asustar. Es para matar.
El camión paró. El papá salió del camión. La niña estaba ya muerta casi. Y este señor no paró y se fue. Se fue. No esperó. Se fue. La policía vino a donde estaba esa niña. La ambulancia vino donde estaba la niña. Ese hombre no estaba ahí. Ese hombre sabe lo que hizo. Ese hombre sabe que mató a esa niña. Y yo sé que le duele porque la mató. Y él sabe en la conciencia de él que la mató. Por eso es que él dice, me siento mal. Te sientes mal porque la mataste. ¿Entiendes? Y hay que tener las consecuencias sobre esas acciones. Porque, o si no, nos estamos viviendo en un lugar donde no hay leyes y no hay respeto.
We live in a state that has a very strong gun culture, gives a lot of deference to gun owners and their ability to defend themselves in daily situations. You have in a state where they can stand the gun rights, allow pretty much anybody to carry a gun, no training. Do you think any of that might have played a role in the grand jury decision?
Maybe, but I want to ask you a question, a rhetorical question. Because we do live in the state of Texas. Do you think Charlie Manson should be carrying a gun in the state of Texas? No, you don't, right? Do you think a mass murderer should just be walking around and be able to get a gun and go into a shop and just go get an AR and, walk into a school and just start shooting people? No, you don't. There has to be some checks and balances within the laws of the state. Yeah, we are pro-gun. And guns are a big part of Texas, but you have to have a responsible gun owner. It's a big responsibility to own a weapon that can take a life. And please, people don't understand that concept. And we have rural Texas, and that's, a gun for them is a way of life. And that's something that we have to respect. But here in the city, what happens is we have road rage incidents. We have people pulling guns for any reason. We have people carrying guns that are mentally ill that should not have a gun. And these are all the issues that then affect gun ownership. You can't take a blanket approach and say, you know what, the Second Amendment, everybody's entitled to bear arms militia style. No, that's not the intent, because we don't intend for crazy people to be walking around with machine guns walking into school and killing people. Or, in this case, having one on their person and discharging a firearm that killed a 9-year-old little girl on a bad, reckless decision that he knows that he made. And that's my issue with the gun in the state of Texas. We have to be responsible gun owners. And that should be the law.
And the law recognizes that reasonable belief that a person who's mentally ill should not be carrying a weapon, should not have access to a weapon, because they're so inherently dangerous and mistakes can happen in such a quick instant and it can ruin the lives of many, many people. The law recognizes that mentally ill people should not be bearing arms.
And you know why? Because mentally ill people are a danger to themselves and others. That's why we don't allow them to go ahead and have the gun. So, you have to start with just common sense. If you understand a common sense approach to gun ownership, then you're going to have responsible people carrying guns. You're probably going to have less gun violence because the gun is not going to be available to these individuals that can actually hurt themselves or hurt others. And I think that's one of the key issues in this case as well.
Abogado, ¿cuál sería ya para que repita los pasos a seguir en español una vez que tomó el gran jurado esta decisión?
La familia, la semana que viene, vamos a un meeting con un abogado que es un abogado bien famoso aquí en Estados Unidos, y está en California ahora y tuvo su tiempo la semana que viene, el miércoles, a ver a la familia. Le hemos mandado toda la evidencia. Él va a ver la evidencia, se quiere sentar con la familia, va a hacer eso sin ningún costo a la familia para mirar y a ver si se hubiera presentado el caso diferente. A lo mejor el grand jury no viene y dice que sí, que los cargos deben de seguir. So, ese es el próximo paso en el caso. Hay que hacer todo bien, vamos a hacerlo como la ley pide, pero vamos a seguir adelante y buscar justicia, porque esto no para aquí.
Are you guys seeking any civil litigation against the DA's office or Earls?
We're not seeking litigation against the DA's office because they have governmental immunity, first of all. Second of all, I don't believe that my judgment can override another lawyer's judgment, because I don't feel they were grossly negligent in their approach. It's just a different approach. As far as Mr. Earls is concerned, yeah, he'll be a named defendant in a wrongful death action, and we look forward to taking his deposition here shortly. And I don't think he can hide under the Fifth Amendment, so we look forward to him.
We just need accountability.
Accountability
We need
is the word.
accountability. We're tired. We've been fighting so much for a lot of different people here in Houston. We're trying to help others just not have to go through all the things that we had to go through, teaching them what we've learned along the way. This Sunday is the funeral for Christina's daughter, the 5-year-old that was just shot here in Greens Point. We've been helping that family, trying to go through the process, and they're just getting started with seeking justice. They don't have a defendant on their case. But when we do have a defendant, look at the outcome.
Mr. Earls used an excuse. No accountability. Be accountable for your behavior. If you came out of that car and you came out with that pistol and you were angry and you were mad and you wanted to shoot that robber and you were going to get into it with him in a parking lot.
You should have continued to chase him. Why did you stop? You should have kept chasing him. But that's not what the case. He made sure that he stayed in a safe place, and he shot from a safe place where this man was running away from him. He didn't continue to pursue him. You should have. What did we do to deserve bullets in our truck?
And,
What did we do by just simply driving down the road? What did we do? We didn't do anything.
As you can see, the family's upset, and you know what? We got to carry on. So my job is to help them along this process, and we're going to keep going and gather evidence and gather more evidence until we can make our case, and we will get justice for this family. I thank y'all for being here, and thank you for your time. I appreciate it. Thank you.
Thank you, guys.